President and Chief Litigation Counsel for Tyco International, of which Sensormatic is one of its companies. Dennis Lynch. Dennis is joining us from San Francisco right now. He's on the road. Dennis has a stellar history working both as a litigator at Montgomery McCracken, another fine Philadelphia law firm. Litigated a lot of cases there. He was in-house counsel at Unisys, and then for Tyco since 2004, and is now the Vice President and Chief Litigation Counsel there. Welcome, Dennis. In addition, I have two of my colleagues, my partners here, who were co-counsel with me in the Checkpoint Sensormatic case. Eric Vitalock, who's a partner in the Intellectual Property Department, who has been litigating cases, as have I, been for well over 30 years in the intellectual property space, and has extensive experience. He is actually a real patent lawyer. I'm a patent litigator, but he is a real patent lawyer and patent litigator, and I could not try cases without him. As well, Chuck Marion, my partner, joins us. Chuck was also on the team for the Sensormatic case. Chuck has extensive experience in commercial litigation throughout the country, as well as lots of IP experience, and was invaluable on our team in this case as well. We're here today to talk to you about the subject near and dear to our hearts and yours as well, and that is attorney's fees. We are here to talk about how to relieve the pain of attorney's fees and make the other guy pay. It actually can be done. We have done it. The Supreme Court on the Octane Fitness case has made it easier to do, although not easy. I've always said that every lawyer personally should actually have to hire another lawyer and get a legal bill and pay a legal bill, because it is a sobering experience. And it's one that I'm sure most of you know what it's like, because I think most of our audience are in-house counsel. We provided you some materials, some handouts, which include the decisions in the Supreme Court Octane Fitness case, the remand decision in the Octane Fitness case, which is as important as the Supreme Court case, and a copy of our case in the Sensormatic case. I'm going to turn it over initially to Dennis Lynch to give you the client's perspective in these cases. Then I'm going to talk about Octane Fitness and our particular case, the Sensormatic case. Then Eric will talk about post-Octane Fitness denial cases where courts have denied findings of exceptionality and or attorney's fees awards. And then Chuck will do what we call the step 3 in the Octane Fitness process. After you do the determination of whether or not the case is exceptional, the court then determines in step 2 whether or not attorney's fees should be awarded at all, and if so, what percentage, some, all, or none. And then the third step, which Chuck will talk about, and that is the actual award of the amount and how those challenges are. So having said that, I'm going to turn this over to Dennis Lynch to give us the client's perspective. Dennis, are you out there in San Francisco?
I am indeed. How are you? And thank you.
Thank you, Dennis. Welcome.
And welcome, everybody. I have to tell you that having dealt with patent cases for many years, and both bringing them as an affirmative case as well as defending them for a number of companies, I really never thought about attorney's fees. It wasn't something that normally, you would consider as part of your analysis about the merits or strengths and weaknesses of a case that you're dealing with. But it became clear during this trial that that was something we should look into. And I can tell you that I did not try to raise expectations within the company that that would be a successful avenue for us to take. But the more I watched how well Kelly and the team brought forward this case, the more I thought this is something we should look into. And Section 285 is, again, not a part of the code that I was familiar with. What I think is important, though, is, and I've learned from this experience, is that you should think about that. Especially in our situation, and I can't get too much into the case because it's still pending in front of the judge, but this was a major competitor of ours, so there was a desire on the part of the company, the business leaders, to fight, to take this to the mat and to get as much out of this case as we could. The approach that was brought by our adversary was one that gave us that opportunity. And I thought that really one of the brilliant parts of the case was that we did have the affirmative defense of inequitable conduct, and that's usually sort of a bucket kind of thing you throw into a case. Well, it ends up being important in this case, and that being an affirmative defense allowed us to go to the jury and get an advisory opinion and allowed Judge Tucker to give us the award that we got. One of the things that's kind of interesting to me is that in the process of this case, during this case, separately from this litigation, I was asked to get involved with some other companies to lobby on Capitol Hill for patent reform. And one of the items that's been discussed in Washington in the way of reforming patent litigation is the shifting of fees. In other words, the prevailing party gets the fees. Well, frankly, I've always said that's already in the code. And the Supreme Court case that Kelly mentioned, Octane Fitness, really has allowed companies to use that as a part of their defense in a patent litigation. So when I was on Capitol Hill, I was saying to people, I would just skip putting into law something new relating to shifting of fees because the Supreme Court's already done it. So those are just some thoughts I have about not just our case, but also how patent litigation is playing out in the U.S. today. I think that, it's still an extraordinary thing to get attorney's fees in any kind of case. But I do think that it's something that one should think about when you are presented with a case, certainly by one of your major competitors. It's something you need to work into your trial analysis, your approach to the trial, and ultimately your advice to the client. And on the flip side, I would also say, as somebody who also brings a number of affirmative cases, keep that in mind as well. We do not, as a company, bring cases lightly, and never would. But I think that it is sobering to know that it can happen to you as well. And if you don't play fair, and if you don't present a good, strong case and haven't thought it through, you also could be liable for attorney's fees at the end of the day. So in a lot of respects, I think that where the law has gone and is moving to as far as shifting of attorney's fees is a good thing in patent litigation because it's a difficult area. It's a place that affects people's intellectual property, their assets, and depending on your company, could be your main asset. So it should not be done frivolously. It should be something that is considered and done honestly. So I don't know. Those are my thoughts, Kelly. Happy to take any questions or turn it over to you for further discussion.
That's very helpful. Thank you, Dennis. I do have a couple of questions I think might be instructive for our audience here. In light of the fact that the Octane Fitness case, of course, rejected the old Brooks high-level test and really, as I said in my materials, it changes everything. From an in-house counsel perspective, in terms of going forward now, in light of the Octane Fitness tests, would you recommend to our assembled august group here any changes in terms of how you would handle either defending and or prosecuting a claim in patent infringement in light of the Octane Fitness change and the easier way that one can recover attorney's fees?
Yeah, I don't think it changes the analysis about the merits of a case. I think you need to do that no matter what. I do think, though, that you should think about the end result. In other words, you should bake in earlier on in your analysis, perhaps, and your strategy on how you want this to play out and how it will end up that allows you, at the end of the day, if you win, to be able to get attorney's fees. It's, again, what I mentioned before, it's not something that I honestly thought about before. I do now, because now I appreciate the fact that there is an end game. It's not just winning the case, but there's something beyond that.
Well, let me ask you a more specific question here, and of course it was raised in our case in that one of the reasons that Judge Tucker found that our Checkpoint's claim was inadequately investigated pre-suit is that there had been no opinion, written or oral, from competent U.S. Patent Counsel on infringement by an examination of the actual accused product of any defendant. And while the Supreme Court did not actually specifically say that in order to bring a patent infringement action, you must have in your hand a written opinion from competent patent counsel that has analyzed the actual accused product and compared it to the claims of the patent, I think one might read from that and from subsequent cases that both Eric and I will talk about, that certainly would be best practices to do so. Do you have any thoughts about that in terms of either from a plaintiff's perspective or defendant's perspective about requiring a written opinion prior to filing suit?
Well, of course, yeah. I mean, that's something that one assumes you're going to do. The interesting thing is I started my career at Montgomery McCracken, and I represented a lot of lawyers in legal malpractice cases, and it turned out that I ended up representing a lot of patent lawyers because after the Federal Circuit came into existence, they really changed the law. And it used to be that you would get a couple paragraph opinion letter from a patent lawyer and you were good to go. The Federal Circuit changed that, frankly, and it was a shock to a lot of patent lawyers who had lived under a different regime. So yes, you need to get not just an opinion letter, but you need one that's substantive, that is detailed, that goes through all the factors relating to both the technology and the law relating to whatever the product at issue is. If you don't do that and you haven't documented that, obviously you're really at risk.
Dennis, let me ask you about a second element that came up in our case that comes up in many of the cases where there is an award of attorney's fees and a finding of exceptional, and that is the motivation of the patentee in filing the lawsuit. We live in a day of non-practicing entities. We live in a day of practicing entities that file actions for what turn out to be improper purposes. And in our case, in fact, Judge Tucker found that Checkpoint had brought the suit in bad faith with an improper motive of crippling defendant's business, and that they had not asserted its patent rights, but to interfere improperly with defendant's business and to protect its own competitive advantage. One of the questions comes up and came up in our case was what evidence there is of motivation, be it proper or in these kinds of cases. From the perspective of in-house counsel, do you have any pointers about how one might go about protecting the record, so to speak, as to what your real motivation is in terms of bringing patent actions?
Well, again, since it's still outstanding, I don't want to comment too much about our adversaries' motivation. That said, clearly you go to your business people. They know the market. They know your competitors. They know what's going on as far as who's doing what and why. And if you have that if you understand that, then you are better able to advise your client. You're also, frankly, becoming part of the team, right? I mean, you're showing as an in-house lawyer, you're showing your client that you are part of the effort to defend the company, to protect the company, and to promote the company. So, yeah, I mean, you need to do that. I think in this case it was clear that there was a competitive reason why this lawsuit was brought. To your point, Kelly, with the patent trolls out there now, it is very easy for anybody to slap you with a lawsuit. To give you an example, we have been hit with a number of patent troll cases over the years. When I say we, I mean Sensormatic, which is our retail solutions business. There are, and part of the reason is because there's a new area of technology, not that new, frankly, it's been around for a while, called RFID. And there are over 100,000 RFID patents that have been granted since about 1991. So lots of people have these patents, and they can hit you with a lawsuit at any time. That being the case, you've got to be careful making sure you know who it is who's coming at you. And that's the first question, frankly, your businesses will ask you. Who is this person? Where? We don't know them. They're not in the industry. They're not in our world, our market. And that itself is informative because it not just informs you as a person, as a lawyer trying to defend the case and represent your client, but it ultimately is something you can use in court because it's showing a judge that, look, this is a strike suit, pure and simple. Anyway, I mean, I think that's what I would suggest is, of course, again, go to your client, understand the market, understand where they're coming from, and understand who your competitors are.
That's very helpful. Thank you, Dennis. You know, of course, in our case, and this is in the published opinion that we had evidence of and the court found that the general counsel of the plaintiff had threatened one of the defendants prior to filing a lawsuit by saying, we'll make you bleed legal fees, we will put you out of business and make you cry. Needless to say, you don't get that kind of evidence in all cases, but you know, loose lips sink ships, and I like to say, refer to the Joe Kennedy rule. Joseph Kennedy, the father of the patriarch of the Kennedy clan, used to always tell his children that you should not put anything in writing that you wouldn't want to see on the front page of the New York Times the next morning. So I think from a business standpoint, certainly when there's any discussion of motivation in terms of bringing lawsuits, one has to be very careful about what kind of record one creates. In regard to the issue of expert opinions prior to filing a lawsuit, as my colleague Eric Vidlock always points out to me, and I'm sure will do so again today, there is no requirement that one get a written opinion prior to filing a lawsuit. Unlike, say, for instance, in the medical malpractice area, there are now 28 or more states which now require what they call a certificate of merit or an affidavit of merit, that before you can file a medical malpractice action against a physician or a hospital, you must have a certificate from a physician in that specialty certifying that the standard of care has been breached. Those kinds of laws have cut down substantially on the number of malpractice actions, and certainly the ones that lack merit that have been filed around the country. I'm not sure we're heading in that direction in patent litigation, but my take from Octane Fitness is that certainly it would be best practices from a standpoint of prosecuting these actions to have that in hand before one files a patent lawsuit, at least where there's any complication to the claims of the product. Thank you very much, Dennis. I appreciate it. I think Brian has to put a code on the record.
Yeah, thanks, Kelly. For those of you that joined a little later, if you wanted to get CLE credit for today, I'm going to come online with 4 code words you just need to write down and then send me an email later to fill out a form I'll send you. The first code word is just going to be pepper. That's pepper, and then I'll come back in about 15 minutes with the second one. Thanks, Kelly.
Thank you, Brian. Thank you very much, Dennis. I'm going to move on now to talk about Octane Fitness in general, and in our case a little more specifically. The Octane Fitness case, which was decided last April, changed everything. We used to operate under the old Brooks test, which was a very high bar test. The U.S. Supreme Court completely threw that out and essentially set forth a test, which we operate under now, of 2 major issues. One is a case can be exceptional in regard to the substantive strength of the party's position, if that's not sufficiently strong, and 2, if there was an unreasonable manner of litigation. Those are the 2 big sections, the big policy points that the Supreme Court made. In each of those, there are subparts and factors. In the first one, the substantive strengths of the party, the Octane Fitness Court talked about whether or not the case was frivolous. In the second, whether or not there was an improper motivation. The third, whether or not the case was objectively unreasonable from a factual or legal standpoint. The court did note, however, that that wasn't sufficient but not necessary. And then lastly, whether or not the closeness of the questions in the case. So those four factors are actually within that first policy section of substantive strength of the party's position. So you look at all of those factors. The second area is the unreasonable manner in which the case was litigated. In that regard, the court looked to or talked about three factors. The non-prevailing party's pre-filing investigation, was that adequate? Second, the discussions with the prevailing party, which can mean any number of things. In our case, it happened to be some pre-filing threats. And lastly, litigation behavior. So those factors fall within the second group. And then, of course, the Supreme Court went on to talk about the goals of the Section 285 analysis and determination, those goals being how, in a particular case, there was a need to compensate the prevailing party, and more importantly, the need to deter the non-prevailing party from doing this again in the future. And it was not spoken, but the implication there is to deter others from behaving similarly. So that's what the Supreme Court said. Since Octane Fitness, there have been, Eric, what, 75 or so decisions, about 40%. There have been awards by district courts, and a number of different factors have been looked at. Obviously, the factors will be somewhat different when you're looking at whether or not a plaintiff should be awarded the fees or whether or not the defendant should be awarded the fees. And I've listed a whole bunch of those factors in your materials. I'm not going to go through them in detail. You can see what they are. The post-Octane Fitness cases, each one is, because the test is the totality of the circumstances, each one of them really is sui generis. We will all, when we litigate these cases, pick and choose language and similarities between those, and as good lawyers will do. But my position would always be that everyone is sui generis, and the case is determined on its own individual facts. The Octane Fitness remand case is a particularly interesting opinion by Judge Montgomery, and we did include it in your materials. Judge Montgomery found many reasons why Octane Fitness was indeed exceptional and why she awarded fees. You should take a look at those in particular. It's important to remember that, again, this is a three-step process. The first question is, under Octane Fitness, is the case exceptional? And that Octane Fitness gives you the factors for those. It's a very deferential standard. It looks to the district court who lived and breathed the case for months, sometimes many years. In our case, 14 years, I believe. So it's very deferential, and on appeal, it's not a de novo standard anymore because the Hallmark case changed that. But those factors need to be looked at and found by the district court in those circumstances. From these cases where awards have been made, you can draw a number of conclusions. The motivation is going to be looked at very closely. Now, in discovery, you're not going to normally get evidence unless people are very candid in depositions. You're not going to get a lot of evidence of motivation. I think from this, going forward, I know I will be recommending to clients that in any case, number one, if you're a defendant, or actually if you're a plaintiff too, you're going to plead Section 285. So plead it, first of all, so that you have a claim for it. I would say send discovery out. And Octane Fitness, everyone should have standard discovery provisions. Now, you will get objections for work product, attorney-client privilege, et cetera, but at least if you get to the point where there is a motion for exceptional finding and or attorney's fees, you get to that point, you can tell the judge that you did in fact ask for discovery and it was either stayed by court order or by agreement. Therefore, you may be able to get the discovery at that stage. The issues that are raised by the Octane Fitness factors are issues which, upon which you ought to have discovery and upon which you ought to have a hearing. Due process would require that you have a hearing. Now, courts are reluctant to have cases within a case, and they don't want to let this be the tail that wags the dog, but my goodness, if you're going to have a case that might have had several $1 million at issue and have a similar case where there's a claim for several $1 million of attorney's fees, the people against whom those claims would be made should be entitled to due process hearing. So what you might have in an exceptional case hearing, we did not have it in our case. Actually, in our case, there was a hearing, but the opposing party chose not to put on any evidence in that case. I can see going forward in the future people demanding full-blown evidentiary hearings, and possibly with experts, possibly with new experts. For example, it was suggested to me in one the discussion of this that you might have what we call a control expert. That is, you might, in that hearing, actually give the package of materials that the plaintiff had pre-filing to an independent expert without identifying the parties, an independent legal expert to give an opinion as to whether or not that expert would say that best practices would say that case should have been filed. That's kind of an interesting thing. So you're going to have a case within a case, and again, discovery. So that may come. But certainly you're going to be entitled to due process. As far as best practices going forward post-Octane Fitness, certainly, and you'll be amazed at some of the cases that are put in our chart. And by the way, I apologize for not updating the chart to this day, but it's very difficult. If you look at IP Law 360, every day, literally, there is a new fee case. So I will update this continually, but it's updated at least the past 10 days or so. But you will see in here that there are cases where the question of ownership of the patent was at issue, which is a little hard to believe sometimes, but Rule 1 would say, you know what, own the patent if you're the plaintiff. And number 2, if you have any question about whether or not the patent is owned by the plaintiff, you need to take discovery and pursue that. Second, acquire a sample of the actual accused product and have it examined by your experts, be it their legal experts and or your technical experts. And I, again, would think best practice would be to get a written opinion from your experts in detail, as Dennis talked about, as to whether or not that does infringe. I think that's extremely important. Recording your 285 issues. I think everybody should now maintain a Section 285 file. If you have claimed Section 285 in your complaint, or you have had or as a defendant you're claiming it, you need to start keeping a file. And any email, any message, any fax, any whatever piece of evidence that might go to any of the Octane Fitness factors, you better put that in your file, because at some point you may be questioned about it, or you may want to question others about it. You need to be prepared for it, because it someday may be extremely important and you may not be able to retain it. As to evidence of motivation, I think early on you need to consult with your client and determine what that client's motivation is, and make sure that it is memorialized in some respect, and hopefully that it is good faith motivation, of course. You need to, during the litigation, when any of these Octane Fitness factors come up, you need to make sure that you have made a record about them and you've retained those issues, because frequently in litigation things happen at hearings, by emails, by telephone calls, and you don't memorialize them. You need to think throughout the litigation, every moment, whether or not something that has happened can in any way be linked to any of the Octane Fitness factors. And of course that goes to whether or not, if you're a plaintiff, you continue to pursue a lawsuit. As Octane Fitness makes clear, and so do Federal Circuit cases, you must have a continuing analysis of your case, the substantive strength as well as litigation behavior. You may think in good faith you had a great case from the beginning and something happens. Frequently, of course, a bad markman ruling. It may change the Section 285 calculus, and you need to do that, because you will see cases where courts have found that it may not have been exceptional in the beginning, but it became exceptional later on. In terms of when you get to a Section 285 hearing, if you are the subject of a motion demanding an evidentiary hearing, demanding discovery, I think is extremely important, and or perhaps using experts. But I guess the takeaway from this is that there is a way to recover attorney's fees, but you have to be thinking about that from day one. And making a record about it, being prepared, just like from day one you're preparing your jury speech, from day one you ought to be preparing your thoughts about how you will present your Section 285 claim. So that's all I have for the moment. Do we have to do a recording here?
Yeah, thanks, Kelly. This is Brian Dolan again. For folks that are looking for CLE credit, the second code word is going to be fees, F-E-E-S, fees, and the first word was pepper. You need to write those two down, and then we will come back with another one. Thanks, Kelly.
Turn this over now to Eric Bidlock, my partner. Eric can tell us about what has happened post-Octane Fitness in the district courts, where district courts have found cases not exceptional.
Thank you, Kelly. I'm going to be taking the other perspective. What do you do if you find yourself on the receiving end of a fee motion under Section 285? Since Octane Fitness, there have been many more decisions denying fees than granting them. It may seem that fee decisions are coming down regularly, but that's largely, that is true, and more than before Octane, but that's because many, many fee applications are being filed in the wake of Octane. A study from this year reported that there were 65 post-Octane decisions through December of 2014. 20 of them awarded fees, 44 of them denied fees, 1 of them granted fees to one defendant and denied fees to another defendant in the same case. What are the lessons that can be learned from the cases denying fees? Particularly, are there pointers as to how to avoid being on the receiving end of a 285 motion, how to respond to one if you find yourself on the receiving end? As with the cases that grant fees, those denying them turn on unique facts and circumstances, including the propensities of the particular judge in the case. It's very hard to make generalizations, but a few principles stand out that are helpful. First, whether you're a patent owner or an accused infringer, if you're faced with a fee motion, you want to emphasize, as the Supreme Court pointed out in Octane, that exceptional means rare and unusual. To be an exceptional case, the case must be rare and unusual. It must stand out from, as the court said, the run-of-the-mind cases. The conduct complained of thus must go beyond that usually seen in cases vigorously litigated by parties with diametrically opposed positions. Second, and again, whether you're a patent owner or accused infringer, you want to emphasize that the test is the totality of the circumstances, and it refers to the circumstances of the entire case. The Patent Act provides for the declaration of a case as an exceptional case, not individual parts of a case. And some courts have said that Section 285 is not a vehicle for attempting to right every wrong that occurred during the course of a litigation. There are other mechanisms for that, sanctions, contempt, Rule 11, and so on, that should be availed, and it's not a catch-all at the end of the case to try and correct everything. The case must be, for 285 purposes, viewed as a whole as to whether the case stands out as rare and unusual from the cases that the court sees every day. This is not to say that the sum of several isolated wrongs that occurred in the case, or even one wrong, could not satisfy 285, but they may not. And if you're faced with the motion, you want to point that out because courts often say they don't satisfy 285. It's a few single incidences. Third, if you're facing a 285 motion, and this may seem obvious, you want to remind the court that losing the case is not enough. There's a winner and a loser in every case. There must be more than just losing for the case to be exceptional. Like I say, this seems obvious, but it's the way all of the decision should be led, win or lose. Losing a case, losing an argument, losing a position is not enough to support a fee award. The more that's necessary, of course, will be provided by your opponent who's seeking fees and will be contending that the positions you've taken are frivolous, unsupported by the evidence presented and maintained in bad faith, made without adequate pre-complaint or pre-assertion investigation, et cetera, a long list. And this leads to the fourth principle that I've gleaned from the cases denying fees. You want to, and it keys on what Dennis and Kelly has been saying, you want to explain fully and completely to the court why it was fair and reasonable to maintain the positions you took all the way to decision. You'll be facing a judge who has already rejected your position in your claims, but you don't know what the judge really thinks about those positions or those claims. You may be going into it, you want the judge to believe that they're fairly asserted, as you do in presenting them. But the judge may think that, he may think they're weak, or he may even think that they're frivolous. You'll therefore want to move the judge to your view of the claims, or at least to the point where the court will say that the fees were not warranted. There are many examples of fees being denied and the court finding the claims weak or extremely weak, but saying that they were not so weak as to warrant fees. A common situation occurs where a patent owner loses on summary judgment after an earlier adverse claim construction decision. The prevailing party then moves for fees, saying that there was no case to begin with, and the patent owner should have folded his hand after the adverse claim construction, and from that point forward, the case became exceptional. The decisions go both ways on these situations, but if you're defending against the fee motion, you want to explain fully and completely why every step you made along the way was made in good faith and was reasonable. Similarly, it's common that if you're a patent owner and you lose, your pre-complaint investigation will be drawn into question by the opponent seeking fees. As has already been said, probably the single most important thing you can do defensively for yourself as attorney for your client is to have documented all of the steps you've taken in advance of asserting the claim. Who did you talk to? What did you do? What did you learn? Did you inspect the product? Did you test the product? If you did not, why not? Have all that available, even if not produced in the course of the case, but ready to be produced if you need to defend a Section 285 claim. As Kelly mentioned, a formal opinion of counsel is not necessarily in advance of bringing patent litigation, but the closer you come to that with your investigation and your documentation, the better off you'll be if you're defending a fee claim. The same holds true if you're an accused infringer and you're found to have willfully infringed. An opinion of counsel is not necessary to defend against a willful infringement claim, but it sure as heck helps your position if you have that opinion when the jury is deciding willfulness, and even more so in the situation where the jury finds willfulness, but the judge has to independently determine whether the case is exceptional, even with the willfulness finding. And there are cases where the jury finds willfulness, but the judge refuses to find the case exceptional. An opinion of counsel there, again, is very helpful, even though not required. So in summary, the 4 points I wanted to emphasize if you find yourself confronted with a Section 285 motion are, 1, to emphasize that exceptional means rare and unusual, and an exceptional case is a rare and unusual case. To emphasize that the totality of the circumstances test refers to the whole case and not to individual parts of the case. 3, to remind the court that just losing is not a basis for an award of fees. And 4, to be prepared to document and explain the reasonableness of all of your conduct and positions, both pre-litigation and in the course of litigation.
Great. Thank you very much, Eric. That was wonderful. I have a question for you, though. In your analysis of the post-Octane Fitness cases where courts denied the exceptional case motions, did you find any discussion or analysis of, 1, the issue of taking discovery on 285 issues, and 2, holding an evidentiary hearing on those motions?
I did not. In some of the cases, a lot of the cases were very brief. I think a court has made up its mind that, looking at the case as a whole, this is not one for fees. And there were several with very detailed explanations. Those are the important ones to look at, but I could not tell by looking at those whether the information was coming as a result of the record that was already established or post an exceptional case hearing record that was separately made.
Now, there are some cases in which not a full attorney's fees award was awarded, that there was partial, some percentage thereof, or certain aspects of the case. Are you able to draw any lessons from any of those cases as to when a court might say, all right, you get attorney's fees, but you only get some of them?
Courts have done that, and they apportion it. Other courts portion the award and grant fees for part of the case and deny fees for part of the case. There are other cases that say this is not the job of the court, and when the entire case is exceptional, all of the fees that are in conjunction with that are justifiably awarded, and it's not the court's job to go down and say, well, this was legitimate, this is not a legitimate.
Great. Thank you very much, Eric. Appreciate that. Chuck, tell us what happens in step 3 after the court has already determined that the case is exceptional under Octane Fitness and has determined that either all attorney fees and costs should be awarded or some portion thereof. What's the next step for the court, and how is that handled?
Sure. Thanks, Kelly. The next step is the judge will require the prevailing party to submit all of its fees and expenses to the court, and it will provide the other side with an opportunity to assert objections to those fees that are being sought. Given that these are patent cases, and usually the exceptional case motion comes after trial and possibly after an appeal or two, these fees are, as you can imagine, quite substantial, and as the cases reflect. Some judges will not want to delve into the details of these fees, and I have one case that was deemed exceptional where the judge has appointed a special master to make that determination. Some judges will also try to encourage the parties to settle the fee amount and may even send them to their magistrate judge for a settlement conference, which I've seen happen. But otherwise, the court will need to get into the objections. The courts will generally look at the reasonableness of the fees at this stage. They'll look at such things as you would expect in any case, not just a patent case. Is the amount of time spent on the various tasks reasonable? Are the hourly rates charged reasonable for this type of case, in this market? Did the work reflected on the bills actually relate to the pending litigation? Were certain tasks overstaffed by the prevailing party's law firm or whoever? And is there proper documentation for the fees being sought? Often you'll see an objection to the overall amount as being unreasonable, and the parties and the courts often look to the AIPLA survey, which I think is mentioned in the materials, that gives ranges of fees that are typically spent in patent cases with different amounts at issue. So I have seen the parties and the courts look at the AIPLA survey for guidance. The prevailing party submitting their fees should certainly review their bills before submitting them and not be overly greedy. But on the other hand, if the fees wouldn't have been incurred except for the other side's misconduct or for the case being filed at all, those fees should certainly be sought. Some parties we've seen in the cases will object to fees being awarded for unsuccessful motions, certain appeals that may not have been successful. They'll try to parse through the fees and say only certain fees should be awarded. And some courts have gone that route. However, there is good authority that says the fees for all of these tasks should be recoverable by the prevailing party. I believe it's cited in our materials. There's a good decision out of the Northern District of California from March of this year, Kilopass Technology Inc. versus Sidence Corp. And in that case, the court, just read a couple of excerpts because it's quite helpful to a prevailing party seeking all of their fees. The court said that while awarding attorney's fees under Section 285 is limited to exceptional cases, there is nothing in the legislative history or applicable case law to suggest that once a determination that a case is exceptional has been made, court should balk at awarding full fees. To the contrary, Section 285 is a means to make whole a party injured by an egregious abuse of the judicial process. The court went on in that case to say that Sidence, in that case the prevailing party, should be compensated for all patent-related litigation expenses it would not have had to undertake but for Kilopass's misconduct. As the defendant in this case, Sidence would not have incurred any legal costs were it not for Kilopass's claims of infringement, and the prevailing party was therefore entitled to all reasonable attorney's fees arising out of the patent-related litigation. The court finding that that would fulfill Section 285's dual goal of deterrence and restitution. And there was also some language in Judge Tucker's opinion in our case essentially saying the same thing, that the court had the discretion to award all fees and not take a piecemeal approach or parse through the discrete parts. So there is some good authority for that. But, you know, as you can imagine, when fees are submitted, you typically see specific objections for such things as attorneys doing clerical work or secretarial tasks, too many hours being spent on a particular motion or task, more than one lawyer being present for a deposition, or several lawyers being in the courtroom at trial that may not have been necessary. even though you're the prevailing party, you feel, I just went through one of these hearings in another case, and you feel like you're getting beaten up a little bit and being questioned as to your, lawyering. But, you will see, as Kelly and Eric alluded to, some judges will have a sense that perhaps the fees being sought are a little bit more than should be awarded, and they'll give a so-called haircut of 10% or 20%. We've seen that in some of the cases, rather than going line by line through the bills and cutting here and there. You could also see some objections to some of the expenses being sought. For example, as is typical in high-stakes litigation like this, you could see a firm from out of town having their bills expenses for such things as setting up a war room in a hotel and tearing that war room down, and questions arise as to whether the non-prevailing party should be on the hook for those costs. So I've seen those issues arise. And then finally, when it comes to how much should be awarded, the prevailing party should certainly also seek prejudgment interest on their fees. We've done this in our case, and there is case law holding that the trial court does have the power and discretion to award prejudgment interest to the prevailing party. It gets a little tricky on the calculations. We looked at it in our case as, the interest should run from the date when the client paid each of its bills. So you've got a lot of different dates from when the prejudgment interest would be running, and our accountant, it wasn't the easiest task to compile those figures, but we did, and we submitted that to the court. And in a prior decision in our same case, the judge did award prejudgment interest.
Excellent. Thank you so much, Doug. A question for you. Section 285 awards, the court may award at its discretion attorney's fees to the prevailing party. If I am a defendant and I win at a jury trial, as we did in our case, am I automatically entitled to all of my fees for everything, even if I lost motions for discovery or various things during the case? That's number one. And number two, what about on appeal? What happens on appeal? Do I get my appeals fees as well? Is it automatic? Is it discretionary? What are the standards?
I would say that in both cases, it's certainly not automatic. That you do, as a prevailing party, you would certainly seek to obtain all of those fees. I've seen cases kind of going both ways on this. As I said, there is good authority, and we cited it in our motion in our case, for a district court to award all fees to the prevailing party on the basis internally we referred to it as the Killapass, the case they cited, the Killapass but-for test. But for their misconduct in either bringing the litigation or pursuing it wrongfully, the prevailing party would not have had to incur all of these fees and expenses. So I think there is good authority and arguments for why all should be awarded. However, as the Octane Fitness case gets interpreted and applied, there have been some courts which have taken the other approach and said, well, the appeal itself wasn't exceptional, or certain motions weren't really filed in bad faith, and they have parsed it through a little bit. So I think the law is still evolving on that aspect, but you could kind of argue it either way and have authority either way.
Thank you. Well, let me ask you this question. I'll ask this to Dennis and Eric as well, so anybody can jump in on this question, because considering what you said, and if we all look at the AIPLA study and those on this call who have paid bills for patent litigation and know how expensive it can be, what is the future of Section 285 claims? Are we going to see more of them continue and continue? That's number one. And number two, how is this lower bar test of Octane Fitness now going to affect the filing of lawsuits? Are we going to see a diminished group of them, as we did in the malpractice area when affidavits of merit were required? What do you see happening there?
Well, certainly since Octane Fitness, and it's been almost a year and a half now, we've seen a lot of fee petitions being filed, or exceptional case motions being filed, and I think that will continue. And there's a question whether it may even be malpractice not to file one if you're a prevailing party, because you certainly have a shot with Octane Fitness having lowered the bar. As you've all said, not every case that you win is going to be exceptional, but if you have some facts that support it, certainly it's something you should look at doing. I've forgotten the other part of your question.
Well, I want to turn this to Dennis. Dennis,
yeah.
Maybe you have some thoughts on this as to how, in a year and a half of living with Octane Fitness hanging over everyone's head from the perspective of being both a plaintiff and a defendant, as your companies are on occasion. Have you seen any effect, number one, and do you see it affecting us in the future?
I don't see any specific result. In other words, I don't see a major shift. I do hope, though, that it makes people think twice before they bring a lawsuit. The other thing that's, I think, helpful, frankly, is that this whole part of the litigation where you're arguing about fees is educating the court, the entire court system. These are expensive cases, and if they are not well managed, meaning if the judges aren't engaged, it costs an enormous amount of money for both parties, especially for the defendant. So I'm hopeful that one of the positive aspects of all of this is that we will get judges more in tune with the realities, the financial realities of patent litigation. But I really don't see much in the way of a difference in as far as whether or not patent litigation is being initiated or not. But maybe that's just, my small outlook on the world. Again, I think that, frankly, a bigger driver is patent trolls who are just bringing it because that's what their business model is.
Well, thank you. Let me jump in here with my own personal impression as to the effect of Section 285 and Octane Fitness in particular. Is I think, yes, we have seen and will continue to see for a while a flurry of 285 motions and decisions. However, I think that's going to peter out over the next couple of years. Because I think people will start adopting the best practices that we've talked about here today and that Octane Fitness has directed. And as a result, the only motions that will be granted in the future where there was, I guess I have to say, lousy lawyering and or unreasonable clients that either pursue matters for reasons of bad motivation and or without adequate pre-suit investigation. So I think the Supreme Court has sent a message to the bar and to patent owners to behave yourselves and bring only meritorious actions that can be defended. But I could be wrong in that. We'll, I guess, have to see. We do have some questions, and Brian has to put a code on.
Yeah, let me give you the last two codes since we're running towards the end of the hour today. For CLE, the third word is going to be claim, C-L-A-I-M, and the fourth word will be Hamilton. So the four words, again, are pepper, fees, claim, and Hamilton. And I'll put on my email address for the last slide when we're done in a couple minutes for you to send me a note if you want the form. Thanks, Kelly.
Great. Thank you, Brian. We do have some questions, and if you have any questions, you can email them to Brian and we'll, for anyone in particular. But this one goes to a future reference. Question is, it seems like the America Invents Act and other rulings such as Alice have significantly cut back on non-practicing entity lawsuits and other patent lawsuits. Do you agree with that, and if so, to what extent? I will just observe that I just saw a statistic recently that the pace right now of patent lawsuits being filed is at about 6,000 per year, and I can tell from past experience that only about 200 of those go to jury trial. So that tells you what happens to the rest of them. As to whether or not there are 6,000 a year is markedly different from the last few years, I frankly think that's a little bit of an uptick. So I guess my answer would be that no, it has not. Now, maybe there are other reasons why it's increased. But Eric or Chuck or Dennis, do you want to address that?
I think there has been a slowing generally because of Alice. People rethinking their cases. There are a lot of the cases where software, computer systems, business methods, Alice has put a big dent in that. But I've also heard and seen that they seem to be picking up again as patent owners are reevaluating their position. I also think that, along with the prior discussion, that Section 285 has now become part of the calculus in all patent litigation for both parties bringing cases and parties defending thinking about, and I think that may also factor into the slowdown we saw, but people learning about it, figuring it out, and proceeding again.
How do the people in this group feel about threatening a Section 285 motion in order to have the other party reevaluate his or her position? that a good thing to do, a bad thing to do? Do you have to do it in a particular way?
I think you have to have a sound basis for doing it, but as soon as you do, might as well raise it. Put the other side on notice that we have problems with this conduct.
Would it be best practices
with this claim? Yeah.
Would it be best practices to continually and repeatedly or periodically remind opposing counsel that your case still has no merit, and now that we've taken more discovery, it has no merit for several more reasons?
Yeah, I agree.
What about the non-practice?
Just on that last point, Kelly, some of the cases look at a situation where a party basically is given or discovers evidence showing its case is, either frivolous or baseless, and they continue then with the litigation and prolong it. They could be found to have engaged in exceptional misconduct.
For the additional fees.
Right. So I think it is good to periodically, for sure, send some sort of written communication to the other side.
How important is the differential between whether or not a plaintiff patentee is a non-practicing entity or a practicing entity? And in our particular case, Checkpoint Systems is a company that manufactures lots of products, et cetera, so it is not a non-practicing entity. In that particular case, the patent was not one that they had ever made a product based upon or anyone else had, so at least for that patent, they were a non-practicing entity. There are other cases, for example, the Lending Tree case, which in the materials is a case in which Lending Tree was a business that actually utilized services based upon patents, so it was not a non-practicing entity. Is that a factor in these cases? Should it be?
Some judges have viewed it that way, but most judges, and I think, do not view the need to manufacture as a requirement or as an important factor in assessing the claim. A patent owner with a valid patent has a right to exclude others from practicing the invention, and there's no need for that patent owner to make and use the technology in the patent. That's the way the statute is written. The problem arises, and the troll issue arises when you have weak patent claims, high cost of litigation, and parties with weak claims extorting low-value settlements or settlements lower than the cost of litigation in that situation. I think that's the problem. I think having 285 run the risk of turning the fees around in that situation is a helpful measure that may fully address the problem eventually. But I don't think non-practicing it's the term. It's the term instead of trolled that's often used, but the fact that the party, a patent owner, doesn't manufacture should not be determinative.
If a patentee is facing a Section 285 motion, which could involve millions of dollars, does it behoove a patentee to demand an evidentiary hearing, bring in their attorneys, bring in their experts to testify before the court as to how much pre-trial investigation they did, pre-suit investigation they did, how much good faith they had, basically to address the Octane Fitness factors up front with new testimony that may not have had gone in connection with the case or discovered in the case? Is that what someone facing a 285 motion should do?
I think they have to. If the pre-suit investigation is seriously being challenged, and as attorney point, they have to defend it as strongly as possible on that point.
I think there was at least one case post-Octane, I can't remember the name of the case, it's probably in the materials, which does say that the court was reluctant to basically have a case within a case and to let this tail wag the dog, and it was some indication that the court was not going to permit extensive discovery and or hearings, but it would seem to me logical that in this nation where we value due process so highly, that if you were facing a multi-million-dollar judgment, whether it be on a Section 285 claim or a patent infringement claim, you would be entitled to discovery, that you would be entitled to an evidentiary hearing, that you'd be entitled to argument, et cetera.
I agree.
Absolutely. I agree as well. I think we're near the end. Dennis, any final comments? Because I can't see your face.
I don't, but thank you all for joining, and I thought it was informative.
Thank you very much, Dennis. Appreciate your help. Thank you, Eric. Thank you, Chuck. Thank you, Brian. And thank you all, audience. I hope you enjoyed this. Come again. Take care.